government for causing that person's harm. The government placed that person in a position of danger. And that's what we are trying to prove in our cases, because there's a lot of evidence from federal government's own documents that show they knew what pursuing fossil fuel energy system would do, and in spite of that knowledge, they went ahead with these policies anyway. Do we have precedent? This is Claudette Colvin. A lot of the precedent that we look to is the civil rights cases of the 50s and 60s in the United States. And Claudette Colvin, when she was 15 years old, she refused to give up her seat in a segregated bus to a white woman. And ultimately, this led, she was a plaintiff in a case that was filed and made its way up to the United States Supreme Court. And this was actually before Rosa Parks undertook the same conduct on a bus. Claudette was one of the first people to do that, and she was 15 years old when she undertook that activity. And ultimately, her case, she testified in court, and her case resulted in the segregation of buses, that policy and practice being found unconstitutional and violative of the Equal Protection Clause. So there's we have a lot of historical lessons of when government is creating these discriminatory and harmful systems, courts can step in to fix that. Brown versus Board of Education is a very good example of when the government created segregated schools. They were able to review that system, and courts came in and corrected that. And it's also important to remember that those kinds of cases in social movements, it was not the litigation alone. They were always coupled with social movements. You had the bus boycotts, and you had Brown versus Board of Education. You have the Love is Love campaign, and you have the gay marriage litigation that has been going on in the United States. And we're starting to see that here as well with the climate movement. You guys saw it probably best of anyone here in Canada on Friday. The picture that I saw in Montreal was unlike anything I'd ever seen before. So these kinds of movements are very important, and the litigation is a big part of that, because court decisions can matter, and while it can take a long time to get them, once you get that decision, things can happen very, very quickly, as long as society is ready for that. We filed our case in 2015 against President Obama. We have 21 plaintiffs, all of whom live in various places across the United States. They all have their own stories of how they've been impacted by climate change. We have one young plaintiff who's Navajo. She had to move off of her reservation and her farm on the Navajo reservation because the springs dried up, and she was no longer able to feed her family or her animals with water because of that activity. And removing yourself from reservation, there's tremendous cultural consequences to that. We have a plaintiff in Louisiana whose home was flooded in a place that had never flooded before in inland Louisiana. We have a plaintiff named Levi who lives on a barrier island off the coast of Florida. He's had to evacuate from his home a number of times because of hurricanes, and it's more than likely that he won't be able to share his home with his children because of where he is located. The government has moved to dismiss our case, and on November 10th, 2016, it was actually 2 days after Mr. Trump was elected. So the nation, many parts of the nation were in mourning for many reasons, but Judge Aiken, a district court judge in the District of Oregon, a federal district court judge, she issued a beautiful decision that I encourage all of you to read. And in this case, she made it very clear that when governmental action affirmatively and substantially damages the climate system in a way that will cause human deaths, shorten human lifespans, result in widespread damage to property, threaten human food sources, and dramatically alter the planet's ecosystem, it states a claim for a due process violation. And in this case, she recognized that there is a fundamental right to a stable climate system that sustains human life and liberties. That is not a fundamental right that's written explicitly into the Constitution, but she has read that into the text of the Constitution. There's a way for courts to recognize new fundamental rights. In U.S. jurisprudence, we've seen that in the context of privacy, family autonomy, cultural autonomy, personal security, and she has recognized the right to a stable climate system that sustains human life and liberties. And ever since this decision, we have been working to uphold this ruling and to get to trial. As I mentioned, we have the honor to work with a tremendous number of scientists in the work that we do. And, this is from one of the amicus briefs in one of our cases that scientists have prepared. and filed with the court. We're at a very momentous time in our history. We've run out of time. Time's up. Climate change cases have been filed for 40 years in courts, none of which have resulted in any kind of meaningful change with respect to how we get our energy or how we address the climate crisis. So we are really at the last opportunity to avoid the worst impacts of climate change. And that's why we're calling on our courts to get engaged and to start looking at this from a human rights perspective as opposed to an environmental issue that for some reason, particularly courts in America, just don't seem to care that much about. They're very loath to recognize and protect a right to a clean environment. But our thinking is that if you frame it in a way that this is about children's lives, which the climate scientists say it is, that's something that courts can understand and move forward with. So here's just a timeline. This is just an example of some of the evidence that we have. This is for the United States. There's not much different in Canada and many of the other jurisdictions. The knowledge of climate science has been known for decades. And it dates back in the US for many, many different administrations. And it's not just, there was a recognition of the climate danger. We had solutions in 1990, 1992. EPA issued a report, we gotta get off of coal by 2000 if we're gonna avoid catastrophic sea level rise. They understood this tremendously. Dr. James Hansen, one of our experts in our case, he was testifying in 1988, that this is a real problem. People need to wake up and start addressing this. President Obama, he recognizes the reports on climate change he would receive as terrifying. So the government really has a strong understanding of the scientific reality of what's going on. I wanted to talk a little bit about the evidence in our case. We have 23 experts in our case, all of whom have prepared expert reports, all of whom donate their time pro bono, which is pretty remarkable, particularly because all of them have been subject to a deposition. And for those who know, a deposition for attorneys is not a pleasant experience to be deposed by attorneys from the U.S. Department of Justice. But they have all put their work, and it's the best available science, and they've prepared it in an expert report so that the judge is the audience. So it's a really fascinating way to see how the science is compiled in a way that the judge will understand really what does this mean for the youth plaintiffs in the case. And this is just, a very busy graphic looking at effects of climate change on child health. There's many different pathways in which climate change is affecting child health, increased rates of asthma, allergies, the trauma associated with developing in a climate changed world, heat exhaustion, heat stroke. You here in BC have recognized when you have the wildfire smoke, camps were canceled, kids were told to stay inside, football practice, soccer practice canceled. All of these things that are quite remarkable and tragic and very damaging to a young child's life. And it really has, and our argument is that it has a disproportionate impact on children, particularly because children's bodies are just developing. So their lungs can absorb more of the pollution. Their brains are developing at this critical time. So we really need to take so many steps to protect children in so many different areas of our world. We need to make sure that they are growing up in a stable climate system. And the knowledge of this being a child health emergency, this is old news. Here, this comes from August 2005. This is from the US EPA, talking about climate change disproportionately affecting children. This should be a call to action, should it not? When you have your lead scientific agency telling you that there's a child health emergency, when would we not scramble to address this and make sure that we are protecting our children? I mean, it's really remarkable when you see this. The director of the CDC coming to testify in Congress that children are at greater risk here. We have a child health emergency. This is the head of the CDC coming in and saying that. That should spur action, right? As working in the medical realm, these messages are important. There's a measles outbreak. That's important for us to address. And the same is going on here, but we just did not have that. They did not put two and two together. And all this time, you hear that testimony in Congress, and in the next room, they're voting to extract more oil from our outer continental shelf. And it's really, really remarkable to see that. Sorry, go too fast. Oh, one thing I did want to mention here, where we get some of the history, one of our experts is Dr. Howard Frumpkin, and he was at the University of Washington School of Public Health. He was the dean there for many, many years. He's now with Wellcome Trust, the Our Health, Our Planet initiative there in London, and he is phenomenal. He was a practicing physician for many years. He's now an epidemiologist, and he specializes in children's health and climate change, and that's what he's doing at the Wellcome Trust in London. But he was one of our experts, and he was actually the first expert to be deposed in the case. And I had the honor of defending his deposition, so I know a little bit about what it is to be an epidemiologist. But the question the DOJ, Department of Justice lawyers kept asking him is, well, have you ever diagnosed somebody with climate change? And he was trying to explain, well, here's the pathways, and trying to explain risk and increased risk, and well, have you ever diagnosed anybody with climate change? And that question was a refrain, and I just will never, Dr. Frumpkin, if any of you know him, is probably the kindest, most patient man I know. And afterwards he said, well, this really makes me question your decision to do pro bono work after an 8-hour deposition. But he was tremendous, and hopefully they learned a little something after hearing him talk. Here's another one of our experts, Dr. Jerry Paulson. He's based in Washington, D.C. He also is he's a pediatrician and has a specialty in environmental health, and particularly environmental health associated with fossil fuel infrastructure. So a lot of his patients are children who live near fossil fuel infrastructure. And just to read his language, it's pretty amazing to see that he's characterizing the government's conduct in perpetuating fossil fuels as, quote, truly shocking. This was in a declaration that he filed with the court, and that the government is knowingly putting children at risk. And again, in his expert report, he talks about all of the different ways that child health is being affected. This is Dr. Lisa Van Susteren. She's a psychiatrist, and she was actually a CIA profiler for many, many years. And she actively sees patients, and she's one of the first to start working on climate change and mental health issues. She's remarkable, and I got to defend her deposition in Washington, D.C., and she's awesome. You can imagine, she's a CIA profiler, so you're like, this is who I want to defend, right? She knows what she's doing, and she also was able to diagnose the DOJ lawyers for all of their idiosyncrasies. So that was very, very helpful. And I will say with Dr. Van Susteren, devastating. I mean, if you just read her words, the magnitude of this impact, the emotional toll of climate change that is even more catastrophic, especially for our children. It has the capacity to destroy children psychologically. That is very, very powerful words from somebody working in this field. It's really remarkable. And Dr. Van Susteren, one thing I'm going to recommend, there's an organization called the Years Project that does climate change videos and things. And she did a great video with the Years Project with Jack Black. He's a comedic actor in the United States, and he's laying on a beach in Miami, and Dr. Van Susteren is giving him therapy. And they're talking about climate change and anxiety. It's fabulous, 8 minutes. If you can find it on Facebook, I highly recommend it. The other way that we've gotten public health evidence into our case is through amicus briefs, so friend of the court briefs. Courts find it very helpful to get information from others who are not necessarily parties in the case, but who are able to provide expert testimony and other information that the courts can find helpful in their decision making. The Harvard School of Public Health wrote this amicus brief. It's a beautiful piece of work. They had hundreds of medical professionals sign on, including some huge organizations, American Academy of Pediatrics, American Lung Associations. It's really remarkable to see it. And they characterize these young plaintiffs as the Juliana generation, because they are generation born into dangerous climate change through no fault of their own. And they talk about how children are especially vulnerable because of their developing bodies, their higher exposure, their behavior patterns. And then also they talk about the economics. Again, remember, all of these sectors are linked. All of these sectors are linked. When you have this public health crisis of such a high order, the economics of that are staggering. And the numbers they're citing are trillions of dollars per year by the end of the century, and that's probably an underestimate when you start to look at the catastrophic consequences of climate change. So those are some different ways how the evidence was submitted in our case. And I love this graph. This graph was done by one of my plaintiffs, Jacob. He lives on a farm in Oregon, and he, when wildfire smoke, it's really difficult for him to work on his farm. He has to wear a really sophisticated mask, but for anyone who's grown up on a farm and works on a farm, you can't stay inside and not get the work done. So, he's highly exposed to that wildfire smoke, which is new in his neck of the woods. That hadn't ever happened before where he's from. And he did this graph, and I love this because our case is probably one of the most procedurally complex cases that you'll ever see. No law student in the United States would understand our procedural journey. We barely understand it ourselves. But to sum up, we've been to the United States Supreme Court 2 times, the Ninth Circuit Court of Appeals 6 times, and we've been in the district court. So we've been bouncing back and forth. The government is filing motions that haven't been filed in most cases, most notably petitions for writs of mandamus, which is essentially you're asking the higher court to dismiss the case because the lower court's gone crazy. That's not the technical term, but that's really what the standard is. They filed a number of those. They filed 12 motions to stay the case. They do not want the evidence getting out in trial. They will do everything in their power to get the evidence from coming out at trial, because they will lose when the evidence comes out at trial. They do not have the evidence to contradict what the medical professionals are saying, what the climate scientists are saying, and what the energy experts are saying. So they do not want this evidence to come out in a court of law, and so that's why we're fighting so hard to get there. Most recently, we just argued on June 4th in Portland, Oregon, an interlocutory appeal, which is an early appeal. Generally, you have trial first, and then you appeal to the higher courts. In our case, we're doing this early appeal because at one point in our case, we were filing briefs in the district court, the Ninth Circuit Court of Appeal, and the Supreme Court at the same time. And the district court judge said, this is insane. This is ridiculous. I think we need a trial. I need a fully developed factual record in this case, but I'm going to send it up for an early appeal unwillingly, but she agreed to do that. So we're currently waiting for a decision from 3 judges on the Ninth Circuit Court of Appeals. We will get back to the U.S. Supreme Court. It's our hope that we'll be able to get to trial first. Our U.S. Supreme Court hates cases that are half-baked. When they get important constitutional cases, they want a fully developed factual record so they can understand how the right would be interpreted and applied. So that's our hope that we'll get that record before we get that up there. I just wanted to close with, what is our remedy in this case? And, scientists, the one thing that scientists are very clear about is, what do we need to do to restore Earth's energy imbalance, which is what is causing climate change. And we need to reduce our atmospheric carbon dioxide concentrations, right? We're well over 415. We're about at 415 today. Scientists say we need to get well below 350 parts per million by the end of the century. There's a number of different pathways. And then we need massive amounts of reforestation and other carbon sequestration activities because of the amount of carbon dioxide that we've already put up into the atmosphere. There's a tremendous amount of studies coming out just last week looking at the extent to which oceans have absorbed carbon dioxide. They absorb about 93.4% and about 25% of our excess heat. So the reason we haven't seen the full impacts of what we've done is because our oceans have been saving us. But they can only take so much, and they're getting close to their carrying capacity, and that's when we're really going to see the ice melt. Our loss of glaciers and sea level rise will start happening very, very quickly. And how do we get there? We need to get off fossil fuels. No energy expert who understands climate danger would tell you something different. I would love to be able to say that an all of the above energy policy, which sounds good and, looks like it's a good option that we can do it, but it just doesn't work. There's no energy expert or climate scientist that would say that we can do that. We need to transition off of fossil fuels. And that doesn't mean just one sector. It means all sectors: transportation, industry, buildings, electricity. All of that needs to be transitioned off of fossil fuels. We need to decarbonize our system. So we have to build, deconstruct our fossil fuel energy system and construct in its place a decarbonized energy system. And what's exciting is that this is feasible. This is economically and technically feasible. So in our case, we can't ask the court to write policies. That's not what the judicial branch does. But we do have to show that there is a remedy that will redress our injuries. So this is why we have done this work. And it shows that there's 350 parts per million pathways that meet current and forecast U.S. energy needs. They're technically and economically feasible, meaning we would be paying about what we've traditionally spent on energy. And you'll have, it's just you're not paying for the fossil fuel subsidies and the infrastructure. So when you look at that and you include those negative costs, you're within the realm of possibility. But what's really clear is we need to start this now. We need to start this yesterday, because rebuilding these systems, something as complex as the energy system, takes time. And for us and for you in Canada to see your government investing in fossil fuel infrastructure just locks in the emissions that your children will be having to deal with for decades. I mean, it's a form of insanity, and something that we need to change. And hopefully that's when the courts will step in and be able to prevent that. So here's a variety of ways to get engaged in the work that we do. I'm going to turn it over to Chris, who's going to talk to you about some of these principles in Canada. But thank you so much for your time and attention, and I look forward to your questions.
Thank you everybody for coming. Thank you to the organizers for bringing us all together. I hope that this is the first of future opportunities to muse over these issues. I am the executive director at an organization called CEL. And CEL has had the privilege recently, well actually not just recently, over a period of time, working with OCT, with this amazing organization that Andrea is part of, on a case. And I guess you may be wondering, after hearing from Andrea, is there going to be a Canadian case? Shouldn't there be a Canadian case? And I think there will be a Canadian case. We can't unveil it in full here this afternoon, but I'm going to tell you a little bit about the work that's been done so far on that case. First of all, I want to tell you a little bit about CEL. CEL is an organization whose mission is to train and inspire the next generation of public interest environmental litigators. We are an organization that feels very strongly that there's a huge capacity gap, and in Canada especially, that we need more young people who are prepared to dedicate themselves to the kind of work that Andrea and OCT and a lot of people in various countries around the world are increasingly doing around climate and around other social causes. So a few years back, we started up an organization that is now a registered charity and that operates here on the West Coast, but offers opportunities to students across the country to work with us on real-life cases in real time. And so we've been working on, for instance, the Pacific Northwest LNG file, bringing the climate science issues to the fore in that case. In fact, that's a photo from us filing a motion in the federal court a couple of summers ago. Those are some of the students that we were working with. We're also very busy working on the Trans Mountain Pipeline file. In fact, we've been working on that file now for a number of years and are currently embroiled in a process that will probably take to the Supreme Court of Canada on that. We're also, of course, and this is, I think, going forward, the biggest file ever, perhaps that we'll ever take. We're working with our Children's Trust, with a law firm called Arvey Finley, which is specialized in constitutional litigation, and with the David Suzuki Foundation on the development of a Canadian case that in many ways is do though, before we talk about the case, and I think that will be an opportunity for the panel to kind of weigh in, and I don't want to anticipate where they might want to go in that discussion. What I'd like to do first though is to kind of set up this proposition that, and I think this is becoming increasingly clear, that in terms of social cause lawyering, in terms of lawyers who want to change the world, and there's various generations in that enterprise, that we have now come to the point where climate litigation is really the most pressing, is where the action is. And things are starting to happen fast, and things are starting to change in, I think, a very positive direction. OCT has been a huge part of that. There's lots of, I think, now, both in the scholarly literature and in the popular press, including on this website here that's run by David Byrne, of all people, from Talking Heads. He's set up a website and he's done a whole series on climate litigation, suing the bastards and how to change the world. So I really think that it's not a surprise that there's lots of people who want to work with SELF, who want to work with OCT. And it's just really up to us to try to figure out ways to harness that amazing energy. I think as we develop that case, it's important for us to think about precursors and precedents and lessons learned from Canada. And I wanted to, because these are two cases I think that will be very relevant to those of you who are concerned about public health issues. I want to talk about some real Canadian heroes who have come before and who I think have offered us some real inspiration in this. On the right there is Ada Lockridge, who, along with Wayne, brought a case for a period of years, about 6 years, to challenge the Ministry of Environment's decision to allow Suncor Refinery to increase its SO2 and other emissions in an area of Ontario called Chemical Valley, shining spotlight on that issue. So I want to talk a little bit about their case, but I also want to talk about the two women on my left, Liz and Emily. Liz is our client. She is a SELF client. She was represented by us for 6 years through a battle over air quality, over children's health, over public health. She was there representing children in her kindergarten class, actually, who were fighting for clean air, who were fighting to make sure that Rio Tinto was held to the best available control technologies in terms of their air emissions into the Kitimat airshed. I think each of these cases, we'll get to them in a minute, and we'll dive into them a little bit more in a minute, but each of these cases have some lessons for us as we think about a climate case. But here's where I want to get a little bit into the weeds, and forgive me, because my day job is as a law prof. I'm going to try to not get too law profy here, but I think for me, here's a lesson, right? Here's why I'm excited about the Juliana approach. On the left-hand column, we see kind of a column that describes what we normally do in public interest litigation. We normally take on a decision that's been made by a minister or by cabinet, like in the case of TMX, or by a bureaucrat in the case of authorizing the Rio Tinto emission increase. We're tackling their decision, and that decision is assessed not on the merits of the science, not on the wisdom of the policy, but on the reasonableness, the supposed reasonableness of whether it's even plausible that a reasonable decision maker could have come up with that decision. That kind of frame, if you put the reasonableness frame on things, you're immediately excluding a lot of important considerations, like the future of the planet, like the best available science, a whole range of policy considerations that the other side, usually the Crown, will say shouldn't be considered. Basically, what you're entering into is a world of deference. It's very hard to win these cases. We keep trying, but it's very hard to win these cases. In part because we're just trying to pick off project by project. And that isn't the way to change the world. I'm not saying the other way is, though. I think it does offer some better opportunities. This is why I'm excited about the case, because bringing the charter into the conversation, putting it front and center in terms of your legal theory, and saying that you want a trial, just like they wanted Juliana. Look what's happening to prevent them from having that trial. It's going to happen, but they faced huge resistance to having a trial of those issues precisely because the question isn't reasonable anymore. The question is whether constitutional rights have been infringed. And we say, just as in Juliana, that we can mount a case under Section 7 of our Constitution, which protects life, liberty, and security of the person, and Section 15, which protects against discrimination, illegal discrimination, and guarantees equal protection under the law. We say that section as well is relevant here to protect, to come to the assistance of young people who have the most at stake in this legal battle. And we say that in this battle, there can be no deference. There is a right and wrong answer, and we're going to get to it through a trial process. I just want to, if I could though, come back to our heroes, Ada and Ron, and Liz and Emily. This Lockridge case, and you have to give them credit because this was never done before. This Lockridge case was an attempt by these two people who are members of a nation residing on a reserve that is right next door to this Suncor refinery in one of the most degraded, nasty air sheds in the country in Chemical Valley, Sarnia. And they decided that this was enough. They would not tolerate another facility being permitted here. They wanted to draw a line, and so they argued Section 7 and 15 of the Charter. Remarkably, although the Charter's been around since 1982, one of the very first public health cases where the Charter has been argued. And predictably, it was a huge battle. Their lawyers were Eco-Justice, which is quite an amazing law firm. They fought hard. It was a very difficult process, but I think one of the lessons from this case was that even though in the legal arena it was difficult to get traction here because Suncor and the government were ganging up, what they were able to do was through a communication strategy, through outreach and education, they were able to shine the light on this problem. And when the Wynne government got elected, there was change. Things were turned around and there was a decision made. We can press pause on this lawsuit, and that's what they did. Unfortunately, there's another lesson there too, which is that when another government came along, many of the things that the Wynne government promised to do were left undone. And so I think there's a good chance that lawsuits like this will have to be brought back when political winds blow in a different direction. This is Anthony, my associate, Anthony Ho at SELG, and I with our client Liz Stennis up in Kitimat. This is a kind of a different story. It's about two kindergarten teachers who decided to stand up to the Ministry of Environment's decision to issue to Rio Tinto a huge increase in their ability to emit SO2 into this airshed on the pretext that they were spending money to upgrade the facility to provide important jobs to the community that everybody wanted, but also on the footing that it was too expensive to put in scrubbers to scrub out that SO2, even though there was a technology available to do it. So we brought argument after argument, eventually deciding to, in the second appeal, use the Charter as the tool of choice. And I could tell you it was a game changer. At that point, everything, I think, took on a new complexion. We had a new government here in British Columbia, which was part of it. But I think what I really perceived from Rio Tinto and the government was they did not want to be defending what was going on here under the Charter. They did not want for young children to be giving testimony about the impacts of SO2 at their school and at their home. And eventually, this was just this past summer, after 6 years working on this file, pretty much full-time at various points, we went into a mediation. The government requested mediation. They basically tore the permit up. We rewrote it. And we got in some new monitors, a new governance system, a lot of promises, a lot more transparency. It wasn't the perfect solution, but it showed what can be done. It really showed me what a game changer arguing charter rights can be, especially when allied with a community that is waking up to its power and media that is beginning to pay attention finally to the story. This is my last slide, and as you can tell, I've been thinking a lot about this case, but I'm being a little careful about how much I say about it. These are some of the questions, okay? These are some of the questions that we're working with Andrea, we're working with lawyers on this case as part of our team every day. These are some of the questions that we're talking about. Firstly, I guess as we embarked on this, we had to think about what kind of team we wanted to put together. And we realized that it would not just be lawyers. We needed the horsepower that students could offer us, and the enthusiasm that students could offer. We needed scientists. We needed communications people. We needed a whole suite of skills to make this lawsuit go. And I think we put together a pretty good team. And I'm looking forward to rolling this lawsuit out. We've also talked a lot about a case theory, and Andrea's addressed this, I think, very well. Climate change is not a problem that lends itself to being addressed in the decision-by-decision judicial review model that traditionally prevails in public interest law. It's important to aggregate the impugned conduct, and it isn't just omissions. It's positive actions like subsidies. But then that raises some questions. Is this a case about complaining about government through the lens of a negative rights case, or is this maybe a case where, and I think this is what Juliana offers, is that there may actually be a moment here that is opened up for us to argue about positive rights, that we do, all of us, have a right to a climate that is capable of sustaining life. This may be that rare case that the court is ready to accept that proposition, or at least to hear evidence about it. I think it's also important, and this again echoes Andrea, that it's important for this case to be about the science, for the science to define the infringement, the point at which government conduct infringes the rights of our young plaintiffs. Not government's failure to meet targets or its promises, but rather the science. And I think the science has to be brought out fully at a trial. It can't just be trotted off the shelf looking at the IPCC reports. It has to actually be litigated in a hearing and cross-examined. And that's going to be something that a judge may be uncomfortable doing, but that will be their job in this case. We're also thinking carefully about where to bring this case. Like Juliana, we want this to be a national case. We think that this is a global issue. And the federal government, our federal government, has a huge responsibility here. We say it's a constitutional responsibility here to take steps to deal with the problem. That in turn informs where we bring the case, and it informs as well the remedy. And again, as Andrea has indicated, it has to be a remedy that, in our view, invests in the court the responsibility of overseeing this issue as it goes forward. We've waited long enough for government to take action. This is a case that cries out, in our view, for courts to take supervision, as they have in other situations where governments have persistently failed to uphold the Constitution. So we're putting together a case that's informed, I think, as I said, by Juliana, but is also homegrown, informed by our own experience here. And we hope that you will follow the case, that you will get involved in various ways to support the case, that you'll tell others about it. And we hope to stay in touch with you. And I thank you so much for your attention today.
Wow, that was a lot to sort of bite off. listen to. There's going to be so much to discuss after the break. I'm so excited. And really looking forward to that. It's so stimulating. We're going to take a 5-minute sort of public health break. Some people may need to leave, so please feel free to do so. It is 5 o'clock and you recognize some people who need to go home. For those of you who will stay, which I hope will be most of you, we will reconvene in about 5 minutes and we'll start with our panel. So we'll get up, stretch, move, start talking about all of these wonderful things that are bouncing around the microphone in the church, and we'll get going in about 5 minutes.
It's better this way.
All right, if we could look at taking our seats again, please. Thank you.
No one that has some combinations.
Well, let's fix up the public health and law people.
So, lawyer, public health lawyer, like,
You know.
Okay. Yeah.
oh, you take my briefcase in case I give you my computer. That's right.
I know you're nice to release people.
We're the world of public health. Okay, so we're now going to get an opportunity to dive into a lot of the fascinating and interesting topics and ideas that were raised by our two speakers. And we're going to do two things here. We've added a couple of public health experts as well as an additional lawyer to the panel. I can never have too many lawyers, that's what I do. And we're going to have a bit of a conversation up here. There's a couple of things that I'm hoping to explore and hear from all five of the panelists, following from the remarks from our two speakers. But we are also going to have an opportunity for the audience to get involved. And so we're going to do that in a specific way. So we're now using, or at least some of us at the school are now using an app. And that app is called Slido, and there's should be a website behind me, and it's platform independent. So if you have a smartphone, access to the internet, and that will allow you to go online. And if you plug in the code that you see behind me, VIH, you can actually ask any question that you want. What will happen is you'll be able to see what other questions people are asking, and you've also got the ability to upvote those questions. And so we'll have an opportunity to ask some of those questions to the panelists, both through the moderated panel, but also towards the end when we have a specific part of the evening just focused on your questions. So hopefully that'll work. I've used it a couple times and it has appeared to work reasonably well. You do need, of course, to have an internet connection, so hopefully using the internet will soon be decarbonized. I don't know what I'll do if it can't be. So I'll just give you a second or two to get that going, and while you do that, I'm going to introduce our new panelists. So in addition to our speakers, we've got Jocelyn Stacey, who is an assistant professor at UBC School of Law, as well as Paul Kershaw, associate professor at SPPH in the Human Early Learning Partnership, and Sarah Henderson, also an associate professor who is also a senior scientist at the BC Center for Disease Control. So trying to bring together some folks who do research in this area with the people from the legal community that are really thinking about bringing these legal arguments forward in terms of seeing action on climate change. So from my perspective, there was an awful lot in those two presentations that were really, really interesting. There's certainly a number of directions that I could impart. I'm just interested in so many aspects of the legal process, and maybe I should have become a lawyer. But where I want to start is really talking about the role of actually how we use research evidence and information and science, and the research that we in the area of public health generate. I mean, one of the things that became clear, particularly in your presentation, is how critical and crucial the scientific evidence is in terms of advancing your arguments. And so my first question to the panelists, and well, I do want to hear from the other three panelists, I think it actually makes sense to sort of start with both Chris and Andrea again, is maybe just spend a minute or two talking a little bit more specifically about how science and the types of, how those types of arguments are advanced or used in the legal arena. Myself as a researcher, as a scientist, I know how to communicate to fellow scientists. I know how to make those arguments to Paul, I know how to make those arguments to Sarah, but I don't really know how to make those arguments to lawyers and particularly more broadly speaking. So we'll have to share the mic. So just as a that means you have control when you have the mic. So just bear in mind we want to hear from everyone to try to keep all of us will try to keep our comments short. So who would like to kind of start with that question, and then maybe I'll invite the other three panelists to sort of chime in on it.
Okay, I'll start. This is a challenge because, scientists, you continually work to prove yourself wrong, right? Because you're always moving, you're trying to investigate, what are you missing, what are you want to know how you're wrong and what's new and what's evolving. And that's tough for a court to be convinced as to what is the true scientific answer, because the court wants to know what's right, what's wrong, what's true, what's false, right? So I think, our experts it's a struggle to figure out how do you convince a court that it's more probable than not that this is what is going on, and that there is a scientific consensus that allows the court to move forward and set a legal standard. But it's a very difficult dance because the law and the science talk in very, very different languages. So it's really important that judges are educated so that they understand the scientific process and how to use scientific evidence in a courtroom, and that it's incumbent upon us to work with our experts so that they are able to accurately tell the scientific story to the judge. And so a good example of this is with sea level rise. Our expert has opined that there will be about 15 to 30 feet of sea level rise by the end of the century. And in his deposition, he makes it very clear, it could be 8 to 13, it could be, on the higher end of that, but it's more likely than not that it will be within this range based on what we know of how sea levels have risen in the past and about what we know about how ice melts and how water warms. So that's his best scientific guess based on his hypothesis, based on his expertise and 50 years of experience working in this area. So a court will need to see that that is how science is done. But it's a struggle because it really does require educated judges in terms of how to utilize science.
I think it's a good question. It does kind of build on a point I was trying to make. Maybe I'll try to elaborate a little bit on the point, which is this, that in the conventional way that you seek to review government decisions, conventional judicial review, there are at least two factors that strongly militate against the court engaging with, in a rigorous way, truly independent science. At least two, maybe more. One is that if the science in question, the independent science, wasn't in the record, it wasn't before the original decision maker, there is a rule, there's an exception to the rule, but the general rule is that evidence can't come in later. So the decision, the reasonableness, to go back to what I was saying before, the reasonableness of the decision is assessed based upon a record which may be very faulty. And often is, because it's the proponent who's got their scientists in the mix, is making sure that they're well paid and have got their science before the decision maker through often very cozy relationships. So that's a problem. And I think part of the remedy for that is to fund groups, like in the case of our client BC Nature, Nature Canada, for those groups to be funded to bring independent science into the process before the decision. So there is some competing science that can be later used when the matter goes forward. But the other factor I think is even more insidious, and Jocelyn, I know, has been writing on this. She's got a chapter coming out on this, which is the predilection of courts to say that we won't deal with the science. We don't want to be an academy of science. That's a terminology. That's a whole doctrine in our federal courts in particular. Part of that is, I think, because of the messiness of, not because the science is necessarily messy, but that there's messy politics and messy choices involved in these cases, and so that's an excuse that we'll use to not getting into it. But also because I think some of them sincerely think that they're not competent to deal with the science. So both of those things take me to this, that I think we want to get in front of a trial judge who we will tell they have to sit and listen to this science. They're a trial judge. The evidence has to come in, and it's your job to listen to it and try to understand it. I think that's really what we're hoping for, that we will get a judge who will understand the situation that they're in, and will grapple with the science in the way that the science deserves to be grappled with.
Chris, I'll answer your question from the perspective of like a public health scholar who's worked recently to bring some of our evidence into Saskatchewan and Ontario courts to defend the constitutionality of pricing pollution in Canada. And on that front, some people here know I do work called Jet Squeeze, which is a public health intervention for younger Canadians. We work with the Canadian Association of Physicians for the Environment, the Public Health Association of BC, and the Saskatchewan Public Health Association, and a couple other groups. And our experience, I think, would be twofold. On the one hand, one of the constraints on bringing the science into the court is that it constantly needs to be framed in the light of previous judicial decisions. And so one of the lenses through which we needed to finagle our evidence was through these other previous decisions. And so that was constantly a conversation with our lawyer about what was going to be the right evidence to feature given the previous decisions. But the second thing I would say is that as in any knowledge mobilization activity, I would be skeptical to say science at the end of the day is going to win the day. Science will be fundamentally critical, but evidence is just one factor in what shapes our decisions, whether they're judicial decisions or otherwise. And there's a range of broader power dynamics at play. I think that lovely diagram that Andrea was showing from one of her clients about just look at a way in which power was used to make our court process not be linear, but keep pushing us back and having some of the earlier work squashed because allegedly lower courts were, did you say insane, something like that, lost it, something like that. And so I think Andrea's observation about the role of social movements accompanying science wherever it goes, whether that's into the courtroom, whether that's into the world of politics more generally to influence what governments do with budget, it's the combination of those two things that's key. And then the framing matters for what's our population more generally, of which the judge will be one, of which the politician will be one. And I think that overarching framing to take our evidence to the public more generally can win the day in a variety of formats.
Sure, just keep.
Pass it along? Okay. So I think that the contributions of the panelists so far have been excellent, and maybe I'll just try to repackage those in a slightly different way. I think one of the really important features of litigation as a site of lawmaking is that it is empowering in many ways to the litigants to be able to frame their own narrative. So picking up on what Paul has said is that the way in which evidence is presented is crucial, but it's only one part of the package. And this relates to what Andrea and Chris were saying, because I think that what's happened in the past with a lot of environmental litigation is that judges thinking that courts are not academies of science, right, feel like they don't have the expertise to really second guess the evidence that's being put before them, particularly by government scientists. And I think they also think that, generally speaking, at least in Canada, governments are doing an okay job, right? Like most of the time, our air seems to be clean, right? We've got lots of green space, like what's the big deal, right? So generally speaking, our government seems to be doing a pretty decent job. But I think what's happened over the last couple of years, maybe five, maybe 10 years, is that we've had this real human rights turn in the way in which environmental claims are being brought before the courts. And that does two things. One, it highlights the ways in which governments are not doing a good job, so it reframes the question in a way that's a lot more pointed at government failure. And the second thing is it shifts the narrative towards something that judges should feel a lot more competent to look at closely, right? So not only are there procedural mechanisms that are available that allow the evidence to be there much more, allows the courts to evaluate the evidence in a more fulsome way, but it actually reframes the case in a way that is more tailored to judges' expertise. Thanks. I just want to thank everybody for inviting me to be part of this conversation. It's been fascinating. My perspective is a little bit different. As Chris mentioned, I'm Senior Environmental Health Scientist at the BC Centre for Disease Control, and we really do research in aid of good policy for the province, and hopefully research that will lead to good policy in Canada. So my perspective on this is a little bit one of alarm in that I'm hearing, new research and its admissibility in the courts might be a problem. And I think we are, from the perspective of tying together climate and health, we're going to hit a turning point, or we're hitting that turning point, or we've hit that turning point in the past few years, and the evidence is coming along. I think the evidence for climate change is very good, but that tie between climate and health has been elusive in many cases. It's a difficult kind of science to do. So I'm really just going to turn this around into a question for the experts again, which is what evidence do you need from us as public health researchers to do what you're trying to do? Is there a piece of research that would, nail it for you guys, or is it less complicated than that? And I'm going to say my perspective on this, and one of the things I worry about so much when it comes to climate is unborn children and infants, because I think they are incredibly at risk from a lot of the things that are happening, and there's a lot of potential for severe harm to the point of death in that very critical stage of human development. And is that the kind of thing that you need? Do I hand this back to Chris?
No, you can. That was a great question.
Yes.
I don't know what I was against. Take it away.
Yes, injury. We need to prove that these children are being injured by the government's conduct in contributing to climate change. So, having physicians, like for example, most physicians, they don't have, what do you call, like a code. You know how you can code when you diagnose somebody? There's no code for climate change induced disaster, something like that, but a lot of physicians are calling for that. So when they have children coming in with asthma attacks because of the wildfire smoke, there's no way to link that to climate change. There's a lot of discussion, I think, in terms of doing that, because where we struggle is proving the injury and then the link to climate change. And it doesn't have to be that you're diagnosed with climate change, but to at least have that conversation that the physicians are aware that there is a link, and that this child is experiencing an asthma attack that he never had before until he was exposed to this wildfire smoke. So maybe that's something that we should be thinking about, because that link there is very, very helpful in terms of the law.
Anybody else want to jump in on that?
I'd add a plea to think of yourselves as teachers, right? So not only doing the research and ensuring that that's there, but making sure that you can communicate that effectively to the public and to lawyers who are, generally speaking, quite afraid of numbers. And judges, right? And so to think about yourselves in that role and in improving scientific literacy, because climate change in some ways is a unique case that we are going to have solid evidence, right, to establish these causal linkages, but that's not the case with many environmental harms, right? And so yes, the study is there for climate change, but also improving literacy, and scientists are in the best position to do that, right? Public health experts in the best position to do that, to think of yourselves as teachers.
I think there's one interesting challenge, or many, but one tension to focus on is, we're in the School of Population and Public Health. Like, we focus on population, so there's good evidence showing that, from Health Canada, 8,000 people died from air pollution last year, which is, double the number of people who died in the opioid crisis, triple the number of people who die in car accidents. So we can give you that kind of population level evidence, but the court needs an individual. The court means, to some degree, specific people. I think you had 27, did you say?
21.
21 going through our children's trust case. So there you need to show the harm done to a particular individual, which is a different kind of evidence than we often are producing for health outcomes that are coming as a result of changes to the climate. And so I don't know if there's a perfect sweet spot for us to close that gap, but that is a bit of a tension for the kind of evidence we're in the business of producing.
Yeah, so I mean, this actually goes nicely into my next question as well as, and picks up on a point from someone in the audience, is that, well, so in my area of research was more in the area of occupational health. We spend a lot of time, squaring the circle or making the connection between whether this individual received this diagnosis, which physicians are very good at doing. But what they're not really good at doing is making the connection between the fact that, as Paul said, there's 8,000 people who, might die. What was the fire? What was your example?
Air pollution.
Air pollution. 8,000 people that died of air pollution or experienced negative health effects. But when someone's in a physician's office, we don't know whether it's that individual. And so you kind of went back to your example of, it was Howard Frumkin, who basically said, he was asked, well, have you ever diagnosed somebody with climate change? And of course the answer is no. So this tension between what we might call in epidemiology, this difference between general causation versus specific causation. So we have very good causal models where the science is very good, that we know what happens at the level of the environment, we know what happens at the level of the population, but how do you prove it? That's your client, even though we know that that person is sick or has experienced negative effects, how do we know that that person actually, that is because of climate change and not something else?
Well, that's why we have an epidemiologist as an expert, and we also have pediatricians and a mental health expert who have individually assessed our plaintiffs and have worked with them. So that's how we're handling it. And I think, the risk part is, why should there be a right to a stable climate system that sustains human life? We have to allege that, climate change is threatening human life, and that's where the risk comes into it. Because you can look at, the loss of life of children between 2 degrees warming versus 1.5 degrees warming, or, the likelihood of increased death. Hopefully we don't have to present a dead body in order to prove causation. Because it gets scary that sometimes that's what you think the courts will require, but hopefully not. So how we're addressing it are those two different levels of causation, with an epidemiologist proving more general causation and links, and then the individual pediatricians and mental health experts who can individually assess the plaintiffs.
So, Sarah, you kind of think about this in your own research. Do you have any sort of thoughts on that? Not an easy question. So.
Well, no, but so, when we're doing science like this, the population scale with administrative health databases, you're right, we use codes. And those codes come from the International Classification of Diseases. Every once in a while they switch over the system and it causes chaos and everybody hates it and what have you. But the addition, working with the developer of those codes to include just one code that says climate related or potentially climate related or anything like that, where that doesn't even have to be the underlying cause. It can go into the secondary cause. That would be so powerful from the epidemiologic perspective, and would only then help to support everything that your pediatricians and your physicians are saying. So that's I'd never even thought of that before in terms of the potential power of that one change, but it's really something to think about. I don't even know how one would go about enacting it, though. I'm certainly going to look it up when we're done.
Yeah, I think the American Academy of Pediatrics has been looking at that. I'll have to look. I'll look at that, because I've heard
But
discussion
it's
of
the World Health Organization that does that, and it seems like the World Health Organization would be pretty supportive of that kind of a change. So
Yeah.
Anybody else want to jump in on this? It's okay, we don't have to, we've got lots of questions here. So I want to follow up, and the next question, and this also sort of incorporates a couple of the questions that I'm getting from the audience is how does this sort of play into our evolving understanding of the importance of Indigenous rights with respect to climate change? And I know, Jocelyn, you've done some work in this area, so I'm just wondering if you could maybe speak to that a little bit.
Sure. So I'll start by acknowledging that I'm a settler working in this area, and so I'm certainly not speaking on behalf of any Indigenous peoples when I present perspectives that I'm aware of. But at a general level, I think it's important to acknowledge first that the way in which climate change is impacting Canada will have, and it already has, a disproportionate impact on Indigenous peoples in Canada. So that's the impact in the north, right, and the Inuit peoples in the north, but also in terms of a whole host of land-based practices, whether it's subsistence, the degradation of subsistence-based practices, cultural practices, right, relationship with the land. And so there's a whole distinctive set of rights and interests and perspectives that need to be recognized there that Indigenous peoples should be playing a leadership role in framing. Under Canadian law, there's certainly rights-based avenues under Section 7 and Section 15, as Chris had up on the slide, for pursuing those claims. So it will be interesting to see when this case is rolled out, the extent to which there may be plaintiffs who are Indigenous that are represented in sort of the group of plaintiffs in the Canadian-based litigation. But there are also distinctive avenues as well. So Section 35 of the Constitution recognizes and affirms the existing Aboriginal treaty rights of Aboriginal peoples in Canada. And so that's that. In BC, we are largely unceded territory, so there are few treaties in the province. And so that recognition includes Aboriginal rights. So rights to hunting, rights to fishing, to trapping, potentially also governance-based rights with respect to those interests, and also Aboriginal title. And so the way in which that area of law is unfolding is changing almost daily. And under that framework, I'll say at a very general level, the Crown has a trust-like relationship over the land, right? And so the only sort of superseding interests that can be exercised by the Crown that justify infringement of those rights are ones that are sort of conservation-based interests, right? To ensure that the land is protected in a way that those rights can be continue to be exercised. And so the Crown has special and distinct sort of trust-like obligations with respect to Indigenous peoples. And so I think we can expect to see further litigation exploring the jurisdiction of Indigenous peoples and the way in which that's being impacted by climate change, in addition to Indigenous perspectives being brought through Section 7, Section 15 claims as well.
Can't improve on that.
Can I add one thing?
Sure.
Just one of the interesting things about the Indigenous population of Canada is the demographics are very different from the rest of the Canadian population. It tends to be quite a bit younger, and another way in which the Indigenous population is sort of disproportionately affected by climate change. This is actually a greater risk to their survival than to the survival of others.
Yeah, and I'll just highlight, I have the honor of representing a number of Native youth in our cases, including Quinault tribal members on the coast of Washington who have to be, their traditional village has to be relocated because of sea level rise and storm damage, as well as a young Colville woman. And the impacts are just tremendous and devastating because of the close connection and tie and the importance of the land, but also the trauma, because we're talking about, dislocation and relocation and the trauma that brings up from the colonial era. It's unfathomable. And then in terms of also the economic consequences, because in our neck of the woods, with reservations, they don't have a tax base, and so their economy is tied to things like casinos and gas stations because they have compacts with the government. So much of their tax base comes from selling fossil fuels. And then here, we're coming in saying you got to decarbonize your economy. But there's no, so there's all sorts of different complexities. And it's just one, and I will say, we wouldn't have salmon in the state of Washington unless the tribes pursued their litigation, which they've been litigating for 150 years in state courts in the state of Washington. We would not have salmon. And here we are, if you look at what the graphs show, the temperature increases. I mean, it is very devastating and scary to see what we're on the precipice to. So incorporating and making sure that First Nations and Native American tribes are, at the forefront of the decision-making processes, because they're also the ones, who are working on the carbon sequestration plans and their forest managements and the very creative concepts that state governments aren't even thinking about. So it's not a seat at the table. It's, something very different. It's writing the policies from my perspective.
Okay. Thank you very much. I have 24 different questions from the audience. We're not going to be able to get through all of them, but we've got quite a few that have percolated to the top. And in fact, the first 4 questions that have been upvoted the most really talk about how people can get involved. And I'm going to break it down because I think there are different answers for different groups of people. So the question, I'm going to read it out because I think it's really well put here, is what are recommendations you would make to students who are not yet in professions where they can make a difference, or how can they make a difference to become engaged? And I'll just note that Chris, in particular, you highlighted the role of students in your own work. So we've got a lot of students in the audience. So what can they do to be a part of this? Or Chris, or
Yeah, well, just from my perspective, it's getting engaged. There's volunteer opportunities. There's joining your youth, the other youth who are striking. There's we also, one of the reasons we enjoy working with CEL so much is we strongly believe in having students contribute to developing the cases and contributing to the cases. So we have a number of students who volunteer. Students have been, one of my clients in Florida wrote the first law requiring all new homes built in South Miami to have solar power panels on them. She wrote that when she was 17 years old. She's now suing her government in the state of Florida. There's other students who are drafting and advocating for climate recovery ordinances, so asking for climate recovery plans based on science. So there's a number of different ways to get engaged and to volunteer and contribute.
Sure, that one's lofted up for me, I think. The public policy that we review either in courts or that we review in the world of politics are set by politicians, and politicians respond to those who organize and show up. We were in the middle of a federal election where everyone in this room on university campus, unless you were just one of those most amazing young geniuses and isn't yet 18, we all have the ability to vote. So right now there's a key opportunity to go and review the platforms, see how the platforms align with the best scientific evidence, think about then how that will shape your vote, and cast your vote accordingly. Encourage others around you who might be skeptical about whether or not voting matters to grow those numbers, because as a younger demographic, we are 1/3 less likely to show up at voting day by comparison with those over the age of 45. And if politics is going to respond to those who organize and show up, if we don't show up, we are then literally creating systemic forces that bias public policymakers and then the judiciary that has to review those policies to not actually prioritize the things that are going to matter for those who actually will populate the planet in 2050 and beyond. To try and help with that, Jen Squeeze is using the power of the Academy to review all the platforms that are on offer in the light of a range of issues from housing to family affordability, but also climate change. And we'll launch that on Wednesday, our first interim analysis, to help people close the gap between what the evidence is calling for and how meaningful the platforms are proposing changes.
I guess I would just add that no matter where you are in your educational arc, whether you're just starting out or you're a tenured professor, I think the challenge is to try to make your work relevant and support this cause in some way. So I know one of the things I didn't mention was that CEL is now, this term, partnering with UBC, Allard School of Law. A little bit informally at this point, we're piloting a project that will allow for Allard students to work with us on some of our cases. We would love that to expand across the country, but thanks to Jocelyn here and actually Stephen Wood, Professor Wood over there, Jocelyn just got elected to the chair of our board, so now she's in a position of power. She can go to the administration, and I think students should go, and that may be even more powerful, and say in law and in public health, and wherever it is that you're studying, let's revisit the curriculum. Let's update it. Let's figure out how to make it more relevant and useful, and create some opportunities for students to have experiential learning. I think that is the wave of the future. When we offered a course at UVic recently, it was sold out within 5 minutes. There was just no room. That's how much demand it was. I think it took people by surprise. So I think that's a really easy one, and I hope to see the results of that encouragement soon.
Putting on my director of Masters of Public Health program, I see a number of MPH students who all of whom are responsible for doing a practicum in order to meet their degree requirements. I wonder if there might be practicum opportunities for our students to contribute 3 months of their time and expertise to the kind of work that's happening. So we should consider exploring that.
So in a similar vein, a number of other people have asked questions about not just students, but more generally how we can get involved. So, what can we do as a School of Population and Public Health, as well as other institutions like ourselves, to create more ties between folks who, whether it's legal or whether it's more in the public policy arena, more regulation, that type of thing. What can we do to strengthen those ties? I mean, to my mind, this might be one of the first times we've had somebody over from the School of Law. It'd be great to see you over here more often. So what can we do to help strengthen those ties? That certainly could be open to anyone on the panel.
The only thing I'll mention is that's one of the benefits of a topic like climate change is the interdisciplinary nature of it all, and to bring in the experts, because all of these issues interrelate together, and we've sort of been able to see that in our case with all 23 of our experts, to see it all in one place, from ocean acidification to public health to mental health to sea level rise to atmospheric sciences to economics. It all blends in. So I think bringing in the interdisciplinary, you guys are at this is a university. It is about interdisciplinary work. So you have economists who are world renowned. You have all of these experts at your disposal. So I think bringing them all together and having that conversation is so important. And after working with the youth, that's what's important to them, because they see the interconnectedness of these issues that I think a lot of the older population don't see. They still see climate change as an environmental issue. So I think being able to bring it in that interdisciplinary way is really, really important.
I didn't ask for the mic, but I got it anyway. I would say that, people have been saying this all along ever since I've been in public health. Health is the thing that can really motivate people around climate change. Everybody understands their health. Everybody understands when their health is being affected. It's a very personal thing when it's too hot out, when it's too smoky out, to name two of my favorite climate-related impacts. Everybody knows that, and if you can make those connections for people that all the time, it just kind of fundamentally underlies everything we do. And climate change doesn't underlie everything we do at SPPH. There's lots of people working in other areas, but how can you bring this into the conversations that you're having in your particular field? And just to play up a little bit more on what Chris said, he said this is the first time we've seen you guys over here. Well, we got to go over there too.
I think you were putting the public health folks on the hot seat, so I'll jump in. So I think one thing we could do more is the Canadian Public Health Association in 2015 published a very provocative and I would say profound discussion paper called Acting on the Ecological Determinants of Health. The last third of that is about an agenda for action that has actually some of the elements that we see up here tonight. One, the focus on interdisciplinarity. Two, using every regulatory and legislative lever at our disposal, which would include going into the courts. Three, focus on joining forces with actors in and outside of the academy on more along the lines of the role of supporting social movements. So I think that the school could to some degree think about the place of, how do we bring that document to life in our school? And I think one thing that Peter's been, Peter Berman, our new relatively newish director, has been doing in our faculty meetings has been to some degree asking us, okay, for what do we want the school to be known, and how will our impact be, assessed by ourselves in terms of, not only what we do in our peer-reviewed journals and whatnot, but the changes that we're bringing about in our community, in our province, our country, and our planet. And I wonder if we think we have some particular set of talents in this school to mobilize as we bridge out with others and think about how we have, knowledge mobilization and change making around how the WHO calls climate change the greatest threat to human health in the 21st century is one of the things by which we evaluate ourselves going forward in a 10-year plan, something like that.
Okay. I got a question from the audience, and I think it's actually a really important question, where they're asking that given that Canada, proportionally doesn't emit that much carbon worldwide, why should we look to the Canadian courts to basically make Canadians change their behavior? So a different perspective, but I think an important perspective because it is an argument that is articulated often in the public policy reason. Who would like to take that?
I'll take a stab at it. I think Andrea will be able to finish it with a flourish. As she always does. So that's an excellent question that needs to be answered squarely. And it's a question that comes up in all of the first generation of these climate cases. Even in jurisdictions that do represent a very high proportionate share of emissions in the US, for instance, it comes up even there. But I think what we're seeing, and OCT has the eagle eye on this because they were involved in a lot of these cases, they support these cases, they work with these lawyers. What we're seeing, I think, is in a variety of jurisdictions around the world, including in the Netherlands, including in lots of other places where the proportionate share is not large, there is emerging a jurisprudential idea that jurisdictions must do what they can. They must do what's fair to uphold their responsibilities in a global environment that's facing a crisis. So although it hasn't been fully articulated and cemented as a legal principle, more and more that issue, that question does get raised and it gets answered and we move on to the merits. And I think that's exciting. I think that represents in a way that we're moving into the second generation of climate litigation.
Oh, I thought we were doing that.
Okay. Well, Greta was asked this question by Representative Graves, a Republican from the state of Louisiana. Louisiana has lost about 2,000 square miles of its coastline because of sea level rise and other issues. But he asked Greta, well, why should the US do something when China and India continue to emit? And she takes the microphone and looks at him and says in her quiet way, well, I get asked the same question by politicians in Sweden. Why should we do something? We're such a small country when the US is emitting all of this. And it was such a great answer because that's all she said. She didn't need to say the moral issue, right? Which is, we keep doing the bad thing because other people are doing that. If we parented like that, I think there'd be a big problem with that, right? And then you look at the per capita emissions of how Canadians live compared to Bangladesh, the Marshall Islands. I mean, there's injustice there. And then Canada has not adequately accounted for its emissions. Canada is peddling its tar sands all over the world. And tar sands is the dirtiest oil you could possibly get. We have to reconstruct our oil refineries to handle that nasty stuff. So if you look at the amount of products that are purchased in Canada that are made in China. Those products are being purchased because of the demand here in Canada. And so there's a way to account for those. It's called consumption-based inventory. And so it says, let's really look at what our economy is and how our economy is contributing to the climate crisis. So there's all of those issues, and legally you could look at what is a meaningful contribution contributing to climate change. But I really like to land on the moral place where Greta landed. You know, I think that's my favorite answer.
If you look at the documents that show what our ecological footprints are as a nation, the Canadians per person have the 8th largest carbon footprint or ecological footprint of any nation on the planet. So I think that feeds into your discussion about moral imperatives.
Can I just,
Yeah, you bet.
can I ask a question? Is there an opportunity here for Canada to show global leadership? Is it possible that this kind of case in the Canadian courts isn't going to get hung up in the same way? We're not going to have the same circular flow chart and to contribute from that perspective?
I'll take a stab at that. I mean, one of the things that I think is to our great advantage in this case is that in trying to support its efforts to have a carbon price across the country, that the federal government has adduced into evidence in the provincial superior courts all sorts of testimony, all sorts of evidence that strongly supports what we're saying. We don't have to prove a lot of the propositions that are key to our case because they're already in evidence. They've been acknowledged and admitted by the defendant here. So I think that's going to put Canada, when they get sued in this case, in a difficult position because they will have admitted and acknowledged many of the key parts of what we need to prove. And in their promises, especially governments of late, in their promises, mostly which have been broken, of course, they imagine a future very much like the one this lawsuit is intended to bring about. So I think that it will be very interesting, and maybe that's where public pressure, I think, can be brought to bear. Will it be a situation where they fight this suit like the Trump government has fought the suit? Or will they take a different approach? Wait and see.
I brought my computer up just to read in some of the language that did get entered into the Ontario and Saskatchewan courts as a result of the pricing pollution cases. So the Court of Appeal for Saskatchewan, the majority wrote, quote, "The factual record presented to the court confirms that climate change caused by anthropogenic greenhouse gas emissions is one of the great existential issues of our time. The pressing importance of limiting such emissions is accepted by all of the participants in these proceedings." The Court of Appeal for Ontario said something similar, quote, "The uncontested evidence before this court, shows that climate change is causing or exacerbating increased frequency and severity of extreme weather events, including droughts, floods, wildfires, and heat waves, degradation of soil and water resources, thawing of permafrost, rising sea levels, ocean acidification, decreased agricultural productivity, species loss and extinction, and expansion of the ranges of life-threatening vector-borne diseases such as Lyme disease and West Nile virus." Those things were beyond contestation in the courts in the way that those particular cases were heard, and I do think it does then present to a federal government, if it ever becomes what's the technical term, not the complainant, but the respondent. Thank you very much, so technical. I do think that actually creates interesting opportunities as a result of their work on defending pollution risk.
I think where the potential to see leadership from the Canadian courts comes from is in terms of the remedy. So I think we do have a very nice foundation here in terms of the division of powers cases. So a different set of constitutional issues that are before the provincial appellate courts and soon to be the Supreme Court of Canada, which I think provide a really great foundation. And I think put the government in a difficult position in terms of how it should respond to a charter claim. But I think where the courts are going to feel really stretched is how to issue an effective remedy. And so maybe public pressure plays a role in that, but I think we really, and certainly careful pleadings plays a role in that. But I think that's in Canada where we want to cast our gaze, because I think the difference between Canada and the US to some extent is that we have climate denialism 2.0 here, which is we accept that climate change is happening, but not that we have to do anything really about it, right? And so that it doesn't actually require transformative change, and that's the bind that courts are going to be in. And Canadian courts do like to try to cut the baby in the middle, so to speak, right? Like they do try to find a middle ground, and so that's the test for leadership in my view.
Okay, thank you very much. And well, I have more questions, and I know there are more questions in the audience, but we've come to the top of the hour, 6 o'clock already. So I'm going to call our inaugural event, Peter, to a close. Hopefully, I think, at least from my perspective, I think that was a great start, and I was very stimulated and learned a lot, and actually will continue to think about some of the things that were brought forward today, because this is a really critical and pressing issue that we need to act on now. Just would like to thank our staff to put this on, and also there was a lot of work both in terms of making sure that this is streamed to UBC Okanagan. So Alexandra, Simona, Michael, and Stefan, thank you very, very much for all of your support here. Would also like to note that we don't have to stop this conversation. We have a reception in the SPPH lobby for the next 45 minutes or so. So come on over. There's drinks. There's probably a few appetizers, and we'll all be there. And you might be able, if you weren't able to get your question and asked during the panel session, you could try and see if you can get it asked during the reception. So thank you all so much for being here.
I'm not sure we can supply